Hi guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeev Bhatia again, and we are back with a new live video on your legal affairs for your CLAT and AILET. So I hope everybody who's joined today is doing great. So this is a very important session for all the students who are going to give the paper on 18th and 11th of December for CLAT and AILET respectively. So all the people who are giving the paper, this session becomes important for all of you. So before I move ahead with the session, a small request to all of you that I always make is to please hit on the like, share and subscribe button, and also don't hit on the bell icon so that you get all the regular updates in your account respectively. And also, if you are not a part of our Telegram channel, do make sure that you're subscribing to our Telegram channel under the name of CLAT@Pratham. You get all the exciting articles and news updates for the law entrance exams here, and also you get updates about your deadlines for your law examinations. And also, if you are looking for any advices from the mentors, and you can also connect to the mentors live there. They are all giving their precious time on these channels and also providing students with mentorship that they require to crack the CLAT exam. If you are looking for any videos that are related to the tips, tricks that are related to preparation, or you are looking for content to read that is related to general knowledge, or it is related to legal affairs, legal current affairs, vocabulary, or you are also looking for help in mathematics, we have uploaded a lot of questionnaires there where you can go and solve these questions and get a hang of all of these things that we are talking about right now. So the first thing that we have on the screen today is coming from Advocate Mukul Rohtagi, who's reappointed as an Attorney General of India. You can see the picture of that person, and he is a senior advocate, and he is set to become an Attorney General of India for the second time. Now, the tenure of Attorney K.K. Venugopal will end on September 30th, and he has refused a second term in the office because of his advanced age. So he wants to take his time off. He's already age 91, and also he'll be there. He's there in the office from last almost 5 years, from June 30th, 2017. So Mukul Rohtagi has served as the Attorney General for 3 years from 2014 and 2017. After that, Attorney General K.K. Venugopal has taken over, and he has been taking this very prestigious position for that long. Now, he's the son of the former Delhi High Court Judge, Justice Awadh Behari Rohtagi. So he is coming from a lineage of judges, and also he's coming from a family of litigators. So you can definitely see that he's been appointed as the Attorney General of India for the second time now. So very important judgment, very important appointment that has happened very recently. So it is very important for you guys to remember this appointment as the Attorney General of India. Now, coming to the committee to draft the National Cooperation Policy. Now, what is this cooperation policy exactly? So the Union Home and the Cooperation Minister Amit Shah has announced that there will be a draft on the National Cooperation Policy. Now, there will be 47 members which will be there in the committee, and that will be formed by Union Minister Suresh Prabhu. And the committee also includes the experts from different cooperative sectors, representative of national, state, district and primary cooperative societies, and registration of cooperative societies of the states and UTs. Now, the policy is being prepared to realize the government's vision of Sahakar Se Prosperity. So that is the earlier current national policy on corporations that were flowed. Now, this policy document is being prepared with a view to fulfill the mandate that is given by the new Ministry of Corporation, which includes strengthening the cooperative movement in the company, deepening its reach at the grassroots level, and promoting a cooperative-based economic development model. So all of these things become very important for a cooperative ministry and also for the country, because all these corporations want to work on the grassroots level and bring the economy up of the country, right? So very important committee. Now, coming to the next judgment that was given by the Supreme Court of India, was that every death in the hospital does not amount to medical negligence. Right? That's what the Supreme Court has said. So the Supreme Court recently held this order by the National Consumer Dispute Redressal Commission, stating that every death that happens in the institutionalized environment of a hospital does not necessarily amount to medical negligence on a hypothetical assumption that there was due or lack in the medical care. So if you can see that there are very important things that a person gets to when he's in the hospital, and there are a lot of protocols that the doctor has to follow. So the person cannot say that hypothetical assumption that there was a due in the medical care that is required by a person when he gets admitted in the hospital. Now the Supreme Court bench of Justice D.Y. Chandrachud and also Justice A.S. Bopanna and Justice J.B. Pardiwala was hearing this civil appeal, okay, where and passed the order by the National Consumer Dispute Resolution Committee, by which a complaint regarding the alleged medical negligence and deficiencies in services was dismissed on the ground that the case was not established conclusively, that they were not able to satisfy the court that there is a matter that has to be somewhere has to be gone out, and like there has to be a proper committee that has to be formed on it. They didn't see that there was a need for it, for any research that is needed on the matter. So they said that every death in an institutional environment of a hospital is not due to medical negligence, and the hypothetical assumption does not work in this case, and it will not be possible for the court to second guess the medical judgments of doctors on the line of medical treatment. So that's what the court has said. Now, coming to the next judgment of the Supreme Court is that delivering used and defective cars against the booking of a new car is unfair trade practice and also dishonest and unethical on the part of the car dealer. Now, the Supreme Court has held that old model cars or defective against the booking of a new car is considered to be a unfair trade practice when the consumer has paid the full sale consideration. That means he has paid the money that is required to buy that car. The court has also added that the practice amounts to dishonesty on the part of the dealer and also against the morality and the ethics of that person. Now, holding so, the court also said that the district consumer forum to replace the car model and also provide a cost of rupees 1 lakh on the car dealer. That means there has to be a penalty that was to be put on the car dealer of rupees 1 lakh. That means the cost, right? They said that they will impose costs on the person who's there on the other side. That means they are fining. They are putting a fine on the person on the other end. Now, the bench was comprising of Justice M.R. Shah, Justice Krishna Murari, and they have passed that non-delivery of a new car can be said to be a part of unfair practice and also against the morality and ethics. And here above, once the new car was booked, the full sale consideration was paid, a duty was cast upon the dealer to deliver the new car, which is not defective. Therefore, the district forum as well as the state commissions were justified in directing the dealer to give a delivery of a new car, right? So they have said it very clearly that this cannot happen. This is immoral and unethical. So that is why they have taken a charge against the dealer for the same. Now, the next part, I'm sorry. Now, the next part is that non-delivery of a new car can be said to be unfair trade, even if they have said to be dishonest on the part of the dealer against the morality and ethics. As observed, once the car was booked, the payment was made fully and there was no defect on the part of the person who is buying the car. The dealer has a duty to provide a car which is not defective in nature. Now, Consumer Protection Act of 1986, right, in exercise of revisional jurisdiction, the National Commission has no jurisdiction to interfere with the concurrent findings that was recorded by the District Forum and the State Commission. So, National Commission cannot say that these things are not correct. They have to agree on the things and the findings of the District Forum and the State Forum, and they have found that there was unfair trade on the part of the dealer, so there has to be a um, remedy that has to be provided to the buyer. So this was a straightforward thing that has come up in the Consumer Protection Act. Now, coming to the next part is that the bail cannot be granted on the ground of accused offered to pay ad interim compensations to the victim, right? So this was the case where the person was accused under so many acts of the Indian Penal Code, 341, 342, also the POSCO Act and also the SC/ST Act. Now that the person was accused that he has forcefully picked up two minor girls on their motorcycle and then they committed gang rape on the girls. So now one of the accused was released on bail and on Jharkhand High Court, and the grounds were the bail were granted to the co-accused because the accused is ready to pay the 1 lakh rupees as a ad interim compensation in favor of the victim. However, the state challenged the impugnant order in the apex court. That means they have applied on the order of the court, and the Supreme Court opinionated that the High Court had not adhered to the parameters that were applicable under the Criminal Procedure Code that should be observed while declining or granting regular bail to accused, especially of heinous crimes, right? So he was a person who has been a part of a heinous crime and he's alleged under the POSCO Act. So such person shouldn't be given a bail like that. The bench of Justice Suryakant and J.B. Pardiwala observed that the offer of the ad interim compensation to victim cannot be a ground to release the accused on bail, right? Because that person is not safe to be in the society, and also the kind of crime that he has committed is heinous in nature. Therefore, the top court has set aside the impugnant order and requested the High Court to hear the bail plea on merits and dispose of it within 3 months. Okay, so they have said that they should look at the case without any bias and they shouldn't part any impugnant orders, and they should follow the rules of that were granted under the Criminal Procedure Code, and then only the bail should be granted. So that's what the Supreme Court has said. Now, coming to the next case that we have in our hand is that right to carry on trade under Article 19 does not confer any right on individual to compel the government to enter into a contract. Okay, so the Delhi High Court observed that Article 19 nor any other provision of the Constitution of India recognizes a right of inheriting an individual to compel the government to enter into a contract. Now, Justice Yashwant Verma added that it is only when the state chooses to enter into a contract by inviting bids and offer that it must follow a fair and transparent process of selection and ensure that all the eligible parties are placed on an even pedestal, right? That's what the court has said. And also, the court makes a note that the state, when it seeks to enter into contractual field, must comply with the mandates that are given under Article 14 of the Constitution, neither Article 19 nor any other provision, inheriting in an individual to compel the government to provide them into a contract or compel a government to enter into the contract. All the articles under 14 and 19 of the Constitution is to respondent under an obligation that as when they do decide to invite tenders or bids, they enter into a contract with an organ of the state. It adopts a fair and a non-arbitrary criteria for awarding of the contract. So that's what the court has said here, and it is very clear what they want to say in this regard also, right? So these are the cases that we had and the news that has followed in this previous week. So do make sure that you are liking this channel, and also don't forget to hit on the subscribe button, and also make sure that you are watching us regularly and also following all our series that are happening on the channel regarding all the courses that are happening all across the country, and all the students who have received their positive CUET results. Congratulations to all of them. I hope you all have a great future ahead. So do take care of yourself and have a nice day ahead. Thank you for joining this live session. Hope to